Let me go straight across to Ashwani Kumar, former law minister of the country, and he's significant because he had piloted a bill that essentially tried to put in a system, a regulatory framework for custodial debts. Appreciate your joining us, Mr. Kumar. You did that, we are told, 10 years ago. You pushed or you tried to push through legislation on custodial debts. We are in 2020 and we still don't have an effective regulatory framework.
Yes, Rajdeep, it is truly shocking, condemnable, and most disturbing. India is a country that claims itself to be a dignitarian democracy, a constitution that is proclaimed as one of the finest constitutions in the world as far as the preservation of the human rights of citizens and individuals is concerned. And yet, in our country, for the last several years, we have tried in vain to have an effective statutory framework to prevent torture in custody. In 2010, a select committee of Rajya Sabha, which I had the privilege and pleasure of chairing, unanimously recommended to the government for enactment of statutory legislation with a view to bridging all the gaps in the law that we thought would help in preventing custodial torture to a very large extent, if not altogether eliminating it. For some reason, between 2011 and 13, this matter could not be taken up in the Houses of Parliament. When the change of government in 2014 took place, I started writing letters to the Prime Minister. I met the Honorable Prime Minister. I met the then Home Minister Rajnath Singh Ji, Mr. Venkaiah Naidu, requested everyone saying that this was a non-partisan issue. This is an act which flows directly from Article 21 of the Constitution that guarantees to all individuals the right to life with dignity. So let us pass this law. Everybody agreed with me, but nothing happened. I went to the Supreme Court, filed a PIL in my own name. And my biggest disappointment comes from the Supreme Court, where despite its own precedents, where the court had nudged Parliament and government to pass appropriate laws, let's say in the case of honor killings, in the case of mob lynchings, but in our particular matter, they refrained from even nudging the government for this law.
You're giving us a very important news point that we should be flashing. You're telling me that for 10 years, you're telling me for 10 years, governments and even the courts have not worked or have not acted on what is a framework that was available for these debts. Please tell us what exactly was this framework on custodial debts. What would it do that it doesn't do at the moment?
Well, look, not only is the framework available, but the Attorney General representing the Government of India in the Supreme Court in my petition assured the Supreme Court that the recommendations of the Law Commission of 2017 under this government, which based its findings on the torture law that we had proposed in the Select Committee in 2010, was seriously considering enacting this legislation. This was also in around 2009.
No. So
even that assurance has not been given.
But what does this, what would this do? What would this do, for example, in a case like Tuticorin, if your legislation was in place, what would be its impact?
This is a comprehensive legislative framework which spells out what would be the consequences and for whom those consequences would ensue if somebody died in custody. How the cases of custodial torture would be investigated. What would be the compensation payable to the victims? What would be the scope of inquiry? Every single detail is spelled out. And let me tell you, since 1997, when India signed the UN Convention Against Torture, we committed ourselves in the International Committee of Nations to come up with a law which would be aligned with the UN Convention. Every year, when the Universal Periodic Review takes place in Geneva, the Attorney General who represents the Government of India has to cut a sorry figure for us not having passed an enabling domestic legislation that would qualify us to sign the UN Convention Against Torture. On 26 June, we celebrated the International Day for Support of Victims of Torture. And today, 4 days thereafter, we are discussing why a dignitarian democracy does not have a law. Krishna Iyer said in 1979 in Sunil Batra's case that human rights,
Right.
the Part 3 guarantees of fundamental human rights which prohibit torture, do not leave the prisoner or the convict at the prison gates. In D.K. Basu, the Supreme Court said that torture is a wound in the soul, and the flag of civilization flies
Right.
half-mast when there is an act of torture. And today, I just cannot understand how a dignitarian Supreme Court can just not take cognizance of the fact that we urgently need a law.
You made a very important point, and it's sad that it's taken tutti kodi for us to wake up to this reality. Here is a former law minister of the country.
Rajdeep,
Yeah. No, I'm talking about the media, sir. I'm not talking about... It's taken us 10 years. You've got enabling domestic legislation in place. We now need it enacted. Here is a former law minister who's laid bare the fact that it's taken us 10 years and we still haven't made any progress. Mr. Kumar?
Yes, but this has to be our Nirbhaya moment as far as law against torture is concerned. The conscience of the nation
we take your point,
must wake up.
We take your point. The conscience of the nation has to wake up after a case like Tuticorin. We will continue to track this case.
Hi everyone, Preeti Chaudhary here. Hope you like this video. For latest news and analysis, like and subscribe to the India Today YouTube channel. And don't forget to press the bell icon to stay updated. Thank you for watching.